Thank you for joining us for our webinar today as we overview the Families First Coronavirus Response Act. Due to the large attendance on this webinar, we are not offering live Q&A. However, we have provided contact information for the presenters in the PowerPoint. We are recording this webinar today, and you will be receiving an email with a link to the survey as well as our SVA resource page where the webinar recording will be available. Our presenters today are Meg Kurlinski and Rebecca Lopez from Godfrey & Kahn, and Eric Trost and Jeffrey Collins from SVA Certified Public Accountants. Meg Kurlinski is a shareholder and Rebecca Lopez is an associate on Godfrey & Kahn's Labor and Employment Practice Group. Meg and Rebecca assist clients with a variety of labor and employment matters. Over the last 2 weeks, they have spent most of their time counseling clients through the many issues affecting their businesses as a result of the COVID-19, and are here today to cover the leave provisions of the new federal law, as well as a few updates. Eric Trost is the principal in charge of tax services, and Jeffrey Collins is a senior tax manager. SVA's tax team is continually monitoring and researching the latest information being released from the IRS, the state of Wisconsin, and federal legislative updates. Rebecca and Meg will be our first presenters today, so I'll turn the presentation over to them.
Hello, everybody, and good afternoon. This is Meg Kurlinski with Godfrey & Kahn. Thank you for joining us today, and thank you, SVA, for inviting us to be part of this webinar. As previously noted, Rebecca and I have been on the phone nonstop with our clients for the last 3 weeks as we all learn together how to navigate the COVID-19 crisis. We hope that in this presentation, we can share with you a practical approach with compliance with the new laws and advise you on how this is going to impact your workplace based on these discussions we've had with clients. We've also reviewed all the questions that you submitted to us previously yesterday and through today. We've tried to incorporate them in our slides, but we've also reserved some time at the end to address some of the frequently asked questions that came up a number of times. I'll warn you that we don't have all the answers. The laws were not perfectly drafted, but what we will try to do is give you all the intel we've gathered to date and what we think we can anticipate. And of course, what our best guess is as to how the laws will be interpreted and implemented. A quick timeline before we get started. If we could advance this, perfect. So this is a nice little overview. If we all think back to January 1, as we were wrapping up New Year's celebrations, not many of us had heard of the coronavirus, and things evolved very quickly from then. In late July, the World Health Organization and the U.S. Health and Human Services declared a public health emergency. March 13th, President Trump declared COVID-19 a national emergency. And quite recently, Governor Evers announced yesterday that he would be issuing a safer at home order. We in fact received that order at approximately 11 o'clock today. I promise you we will discuss that later on in the presentation. We provide this timeline to remind everybody how quickly this crisis has evolved and reinforce that employers need to be nimble as they implement the new laws we are going to discuss. I and most of my clients love a good policy, but it's important to remember that a policy is just a tool and it needs to be used in tandem, case by case, day by day, as we evaluate this situation as it evolves. With respect to the Families First Coronavirus Response Act, the law that we are going to be discussing today, the timeline has been even more compressed. We understand that the House first started drafting this law on March 11. On March 14th, the House passed the FFCRA, and they reserved the right to make clarifying changes, which they did on March 16th. And for those of you out there, like Rebecca and I, that were watching this closely, those clarifications were quite meaningful. And as a result, on March 18th, the act passed Congress and was signed into law. It will take effect 15 days after enactment, so mark your calendars. April 2nd, 2020, the law will take effect. It will then sunset at the end of 2020, so December 31. For those basics behind us, I'm going to give you a quick overview of where we're going with this presentation. Rebecca is going to start off with a discussion of the Paid Sick Leave Act. I'm going to pick up with the Emergencies, Family, and Medical Leave Expansion Act. So many new acronyms for you to incorporate in your vocabulary. And then finally, we are going to touch on some additional guidance and resources. With that, Rebecca?
Thanks, Meg. I appreciate it. So I'm going to chat, as Meg shared, about the Paid Sick Leave Act, or as we call it, the PLSA, which, very high overview, requires covered employers to provide their employees with 2 weeks of paid sick leave for very specific uses. So we're going to walk through a couple of the definitions in terms of who's covered, who's not, and the uses, and point out for you a couple of the nuances to the law. So starting off with who's covered, which employers are covered by this new law. The law defines employer consistent with the Fair Labor Standards Act for private employers, which practically speaking covers most employers that are engaged in interstate commerce, which is most employers. And they have to have less than 500 employees. So if you're an employer with between 1 and 499 employees, you would be covered by the law. For public employers, you have to have at least 1 employee to be covered by this law. Now, one of the questions that Meg and I are hearing relates to whether or not related entities that are separate entities, but related or have some overlap, if they can count their employee population together to get at or above that 500 mark that definitively would exempt them from the law. And this is an interesting nuance because the way employer is defined under the PLSA is different than the way employer is defined under the FMLA, which Meg will speak to when we get to that portion. And so we're waiting to see if there's further guidance from the Secretary of Labor, but without further guidance, our best guess is that the FLSA integrated employer test, the joint employer test under the FLSA is what will control. That is a new test that the regs for just went into effect on March 16th, 2020. And there's guidance online, but it is a fairly complex analysis. And it's one, if you are considering, you're going to want to reach out to legal counsel to discuss the pros and cons of taking the position that you are a joint employer with another employer. In terms of which employees are covered, it is any employee, so we'll head back to that other slide for just a moment. It's any employee that has worked for an employer. So they could be full-time, part-time, temp, or seasonal, regardless of their start date. So on day 1, they are entitled to the leave provisions under the PLSA. And so employees are going to be able to take leave beginning on April 2nd, moving forward without having to satisfy any minimum employment period of time. And so, unlike many of the paid sick leave laws that have gone into effect across the country, in this case, there isn't a waiting period of at least 30 days or 90 days. The employees will be entitled as of day 1. And like the laws that are passed across the country, it is regardless of the number of hours they have worked. So now moving on to the next slide as to what the employees can use the leave for. The statute says that an employee can use leave if they are unable to work or telework due to a need for leave for one of 6 different reasons. So the first one is that the employee is subject to a governmental quarantine or isolation order. I'm going to come back to that in a second because we've seen a lot of questions around this particular reason for leave, and it requires a bit more discussion than the others. The second is that the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. So in this instance, an employee has gotten guidance from a healthcare provider to self-quarantine. Oftentimes this is because the employee might be more susceptible to more significant consequences of COVID-19, but it could be for a number of different reasons. Number 3 is that the employee is experiencing symptoms of COVID-19 and is seeking a diagnosis. So these first 3 reasons and these first 3 paragraphs all relate to the employee themselves either being advised or needing leave for their own purposes or because they're subject to the governmental quarantine or isolation order. Moving on to 4, 5, and 6 on this slide, it relates more to caregiving responsibilities and a catch-all. So under number 4, the employee is caring for an individual subject to governmental or healthcare providers' instructions or self-quarantine. So if the individual, again, it's not specifically a family member, it just says individual, so this is a bit broader than somebody within their household, it's just for another individual, has either been subject to a governmental quarantine or isolation order or has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19, and the employee is caring for that individual, that would be covered by this leave law. In addition, if the employee is caring for a child because the child's school or place of care is closed or unavailable due to COVID-19, that would be a permissible use under the law. Lastly, on number 6, it says that the employee must be experiencing some other substantially similar condition as specified by the Secretary of Health and Human Services in consultation with the Secretary of the Treasury and Secretary of Labor. This indicates that there will be additional guidance, likely by the Secretary of Health and Human Services, that would enumerate what additional uses might be available to employees. Going back up to number 1, one of the questions that we've received from clients is if our employees are subject to a shelter-in-place order, is that the same as a governmental quarantine or isolation order? And so at this point in time, we don't know 100% for certain whether or not a shelter-in-place order will qualify as a governmental quarantine or isolation order. However, what we have noted is that the state and local government's ability to issue orders specifically enumerate shelter-in-place reasonings for issuing an order, and separately in other parts of the statutes have orders specifically referenced as quarantine or isolation orders. Because state and local laws likely define these terms, our recommendation at this point in time is going to be to take a look at those state and local laws in terms of what these terms mean under those laws and how the orders are being issued to determine whether or not the employees being subject to a particular order will fall within this exception. We're also waiting to see if there will be additional guidance from the Secretary of Labor. Moving on to the next slide. The other question we get pretty frequently is how much do we have to pay employees if they are taking leave under the law? So as you will note on this slide, the purpose for which the employee is taking leave will dictate how much the employee is entitled to receive as pay under the law. So if the employee is taking leave for their own purposes because they themselves are subject to a government isolation or quarantine order, they're seeking a medical diagnosis, or because they have been advised by a healthcare provider to self-quarantine, they're entitled to their regular rate of pay, the federal minimum wage, or the state or local minimum wage, whichever is higher. Regular rate of pay, as many of you may know, is a term from the Fair Labor Standards Act. And what it means is that when you're calculating the pay that the employee is entitled to, it is not just their base wage. They're entitled to any additional compensation that should be factored in when you're usually calculating overtime compensation. So that might include non-discretionary bonuses, shift premiums, and the like. If you have questions about what your employee's regular rate of pay is, it's something that you should be discussing with your legal counsel. Now there's a cap up to $511 per day or $5,110 in the aggregate. And this relates to the tax limits in terms of what the employer can claim. And our friends at SVA are going to address that for you in more detail. Now, if the employee is caring for someone who is affected, so under lines 4 to 6 of eligibility on the prior slide, their entitlement to pay is actually reduced to 2/3 of the regular rate of pay, or at a cap of $200 per day, whichever is less. And so it's important to note that. The other question that we hear from our clients is, how much time is the employee entitled to? For those employees who are classified as full-time employees, they are entitled to 80 hours of paid sick leave. If they are a part-time employee, the statute says that they're entitled to a number of hours equal to the number of hours the employee works on average over a 2-week period. And so if you have an employee who typically works 20 hours a week, they would be entitled to a total of 40 hours under the law. So whatever they would work over 2 weeks. Now, some of you might ask, well, what if I have an employee who works a varying schedule? And in that case, the statute expressly states that you should use the number equal to the average number of hours an employee was scheduled per day over a 6-month period. So you'd look back over the last 6 months and calculate what their average daily number of hours was, and then use that to determine what their 2-week entitlement would be. The third question you might ask is, well, what if I have someone who's new or who hasn't worked for at least 6 months and they have a varying schedule? And what the statute directs an employer to do is to use the number of hours the employer reasonably expected to have that employee work over that 2-week period. I'll also note for you 2 important points: that 1, no pay is due to an employee upon termination or separation for any unused time under the PLSA. So if an employee took 40 hours under the PLSA and still had 40 hours available, you're not required as an employer to pay that out upon separation of employment. The other important note is that there is no carryover. So this law sunsets on December 31st, 2020, and none of the time can be banked and carried over for employees into the next year. Moving on to the next slide, we'll talk about a question that we saw come through quite a bit in advance of this webinar. And that question is, what if I already provide my employees paid leave? What happens with that paid leave? The statute specifically states that an employer may not require an employee to exhaust current sick leave before using the PSLA. So if an employee has paid time off, PTO, vacation, or sick leave, they can choose to use the Paid Sick Leave Act time before using their PTO, vacation, or sick leave banks under your current policies. In addition, the statute specifically says that the PSLA does not diminish the rights or benefits an employee is entitled to under any other federal, state, or local law, collective bargaining agreement, or existing employer policy. So what that means is that you cannot deduct the time that they take off under the Paid Sick Leave Act from their PTO bank. It has to still be available to them. And paid sick leave has to be provided in addition to any other paid leave that you have under your policies. The other question that we've heard is whether or not an employer can take retroactive credit for paid time off that it's provided to its employees. So we've seen a number of businesses in trying to help their employees provide some form of paid compensation other than PTO, vacation, or sick leave. They've created some new bank of time or just promised to pay between March 23rd and some future date. And the answer to that is that, at least as written in what we've seen so far, it does not appear that an employer will be able to take credit. That, in fact, the bill goes into effect on April 2nd, and so moving forward, the employee is entitled to that time. An employer will not be able to take credit for the time that it's provided to the employee in the past. Finally, on our last slide here, under the paid sick leave laws, you are, as an employer, are required to post a model notice regarding the employee's rights under the PSLA within 7 days of signing the bill into law. The Secretary of Labor is obligated to issue that model notice. The Department of Labor issued a Q&A on its website. It's a really helpful overview of the law, and it teases under that Q&A that the model notice should be actually issued tomorrow, March 25th, 2020. So stay tuned, keep an eye out on the DOL website. You are going to be required to post the model notice and keep it posted where such notices are customarily posted for employees. So if it's in a break room, it would be posted in the break room. If you normally use your intranet, you would make it available on your intranet. For those of you who have converted to a remote workforce and have been able to do that, I would suggest that you post it somewhere that the employees can access so that they will have access to that model notice. I think that the model notices are going to be helpful in clarifying some of the questions we still have under the law, and hopefully we'll get additional guidance as well from the Secretary of Labor. Back over to you, Meg.
Okay, so now we're going to talk about the Emergency Family and Medical Leave Expansion Act, EFMLA. So in addition to the paid sick leave that Rebecca just spoke about, for which an employee could take that 2-week paid leave entitlement to care for a child off of school, this family and medical leave amendment has provided for additional unpaid and paid leave for that purpose. So the leave we're going to be talking about is for the very narrow purpose of what I will call emergency caregiver leave. And that emergency caregiver leave is for an employee who is unable to work or telework due to the need to leave for the care of a son or daughter under the age of 18 if the school or place of care has closed or the child care provider of the son or daughter is unavailable, all of which have to be due to the COVID-19 state of emergency. So this leave entitlement is created under the framework of the Family and Medical Leave Act. And that's significant for a number of reasons. So for those of you on this webinar that are already covered by the FMLA, so 50 or more employees, and have an FMLA policy in place, this emergency caregiver leave is just an additional possible leave that an employee can take under your FMLA policy. So in addition to a serious health condition, in addition to bonding leave for the birth of a child, they could take emergency caregiver leave. It is, however, all contained within the existing 12-week maximum entitlement for any or all of a combination of those leaves. So flipping over to those folks on this call that as we sit today are not covered by the FMLA, what this does is it does not make everybody eligible for all FMLA entitlements. It merely extends to that workforce leave for this emergency caregiver purpose. So who does this leave actually apply to? So when we're talking about whether you're covered as an employer, similar to the paid sick leave, it's anyone with 1 to 500 employees and all public sector employees. As Rebecca teased, when you're counting the 500 threshold, we have to satisfy the integrated employer test under the FMLA. We do advise that if you are going to attempt to aggregate your related entities or your larger workforce to put yourself over the 500 threshold, that you work with legal counsel, just so that you know the factors considered are common management, interrelation of operations, centralized control of labor relations, and degree of common ownership. If you knock yourself over the 500 employee threshold, you do not have to provide the leave, but you likewise are going to be ineligible for the tax credit. A final note on making your employee count, that is who you have active on payroll, being it full-time, part-time, or employees on leave status will all get you to that 500 number. Now, if we think about employee eligibility, the eligibility requirement is merely 30 calendar days of employment for any employee, full, part-time, temporary. If they're on your payroll, they're a covered employee. We believe that consistent with the FMLA generally, that 30 days of employment calculation is taken at the time that an employee requests leave. So to the extent that you hire someone during 2020, they could become eligible for this leave after 30 days of employment. Moving on to coverage and use. The maximum entitlement for unpaid and paid leave for emergency caregivers is 12 weeks total. And this leave entitlement expires on December 31, 2020. The FMLA never makes anything easy, so they have divided it up into 2 buckets of leave. So your first 2 weeks of leave for emergency caregiver leave is unpaid. Employees may substitute other paid leave like vacation and personal time, or they can even use the paid sick leave that Rebecca summarized. But I want to emphasize may. Under the Act, it is only permissive for employees to substitute leave, and employers may not require the substitution of paid leave during this period of time. After 2 weeks, employers have to provide 10 weeks of paid FMLA. The pay is at no less than 2/3 of the employee's regular rate of pay, subject to the cap of $200 a day or $10,000 in the aggregate. We've received a lot of questions about certification or how does an employer request proof of the need for leave. And the Act provides us no mechanism to certify the leave. And unless additional guidance is provided by the Secretary of Labor, the FMLA's regular certification requirements do not apply to this leave. As a result, as of today, my advice is to not condition leave on the receipt of some kind of certification. I don't have a problem with an employer seeking information from the employee to determine eligibility for leave. And what I mean is having a conversation with the employee and simply asking about what childcare facility is closed, who the caregiver is who's unable to provide care, so you can just make sure that you feel comfortable that they qualify for the leave. On a related matter, clients have proposed a number of hypotheticals about employees who have one caregiver at home that may be able to provide care, and our clients want to know if they have the right to require their employee to show up to work because there's someone else at home. Ultimately, the Act and the FMLA generally do not allow an employer to evaluate who is best qualified to provide care for a child. If an employee otherwise satisfies the requirements, the child is out of school because of the closure due to COVID-19, they are entitled to the leave. Before leaving this slide, I also wanted to address intermittent leave. Intermittent leave is the bane of all FMLA employers' existence. And it is at this time unclear whether intermittent leave is available for emergency caregiver leave. The Act itself does not say affirmatively that it is, and it's unclear under traditional FMLA whether it would be. We are waiting for the Secretary of Labor to speak to this issue. In the meantime, I encourage you to think about whether intermittent leave may in fact be advantageous for you in this circumstance, because you may be able to collaborate with employees in some kind of flexible schedule, flexible work arrangement where you could get the value of their services, at least on a limited basis, while they are also navigating these caregiving responsibilities. Moving on to employee protections. The hallmark of FMLA is that the leave is job protected, meaning that upon exhaustion of leave, employees are returned to their same or equivalent position. Note that you will have seen that there is an exception for 25 employees or less with respect to this job restoration requirement. It is a pretty complex requirement that requires that if the position is eliminated, that loss was a result of a COVID-19 health emergency, that the employer has made reasonable efforts to restore the employee and then contacts the employee when a job becomes available. If you are thinking about doing position eliminations, doing workforce reductions in general, regardless of your size, we do encourage you to reach out to your legal advisor. There's a lot of laws to consider, including these new leave laws. While on leave, employees also receive benefit continuation. That means that they don't get knocked onto COBRA, but they stay on your benefit plans. And the employer continues its normal contributions, and the employee is responsible for their contributions. As we're talking about all of this, do not forget that traditional FMLA is still in place, and those unpaid leave entitlements may very well be triggered by employees that are themselves ill related to COVID-19 or providing care for someone else that might be related to COVID-19. And to the extent that paid leave that Rebecca spoke about is exhausted and they need more time, it would likely be covered by the FMLA. It would be unpaid time and would proceed as normal under your FMLA policies. We encourage you to track and designate all of this leave. Turning to exemptions. When we got the act, they specifically provided for in the act that the Secretary of Labor may affirmatively exclude all healthcare providers and emergency responders from the EFMLA. They did also allow employers to, at this point, exclude healthcare providers and emergency responders from the EFMLA. They have also teased and authorized the Secretary of Labor to exempt small businesses of 50 employees or under from the requirements of these leaves. Now, we've seen a lot teased out there about this. There has been a number of publications from the IRS and the Department of Labor Q&A that Rebecca referenced earlier that imply that an exemption for companies under 50 employees is forthcoming. They even go so far as saying that those regulations will be published in April. Note though, we need to read these closely and proceed with caution. As it has been characterized, they have said that certain employers under 50 employees under certain circumstances will be exempt. So it may not be full relief for those of us that only have 50 employees. I'm going to pass it back over to Rebecca to discuss some additional guidance on essential businesses and Wisconsin unemployment.
Thanks so much, Meg. So moving on to the next slide, you'll see a graphic that comes from the U.S. Department of Homeland Security, Cybersecurity and Infrastructure Security Agency, or CISA. On February 12, 2013, President Obama issued Presidential Policy Directive 21 relating to critical infrastructure in our society in an effort to strengthen and monitor and secure our nation's critical infrastructure. And within that directive, identified 16 critical infrastructure workforce sectors that are important to the U.S. economy and the U.S. community. In November of 2018, Congress passed, and on November 16th, 2018, the President signed into law the Cybersecurity and Infrastructure Security Act of 2018. And under that act, you saw the creation of CISA, which is responsible for protecting the nation's critical infrastructure from attacks. On March 23rd, 2020, CISA issued a memo relating to critical infrastructure and COVID-19. I reference it because although this is just information and guidelines setting forth what our critical infrastructure is and what we should do to protect it, it has really become a base for many of the state and local orders that you have seen issued throughout the country, prohibiting mass gatherings, requiring sheltering in place, and so forth. And oftentimes it is these critical infrastructure businesses that have been exempt from those orders. So when we move on to the next slide and we talk about the orders that have been issued in Wisconsin, what you'll know and see under Governor Evers' new order that was issued today at 11 o'clock and goes into effect tomorrow morning at 8 a.m. is that essential businesses and critical infrastructure are exempt from the limitations set forth in the order. So generally speaking, all individuals present within the state of Wisconsin are being ordered to stay at home or at their place of residence with the exception of allowing persons to leave their homes or residences for essential activities, essential government functions, essential businesses and operations, minimum basic operations, essential travel, and special situations. And each one of those terms that I've just read off of that list are defined in the order. And the essential businesses and operations reference back largely to the CISA memo. And in fact, there is a cite to the CISA memo within the order issued by Governor Evers. I'll also note for you City of Milwaukee employers that there is a local shelter in place order in place as well. And so if you have any questions about whether or not your business is able to continue operating, we would encourage you to reach out so that we can assist you with that analysis. Moving on to the last slide in our presentation, we've received a lot of questions about how unemployment might be impacted by the current crisis. Wisconsin Governor Evers signed an executive order that waived certain requirements for individuals who have been laid off or who are unable to work as a result of COVID-19 from having to conduct work searches consistent with the law and to ensure that they are able to qualify for benefits. So there is a waiting week under Wisconsin law where an employee that's lost their job or who isn't able to work, say due to a layoff, can apply for unemployment insurance benefits. They still have to wait a week before their benefits will begin being paid unless the legislature acts to change that. For those individuals who are laid off or terminated as a part of a reduction in force, they're typically eligible for UI benefits. And the executive order helps to expand that those individuals who are laid off will qualify consistent with federal guidance. On the next slide, you'll see that we've included some information about our resource page. There's links to all of these excellent resources that can help you with navigating some of the questions you might have, including a link to the CISA memo if you'd like to reference that. And with that, I'd like to go ahead and kick it back to Jeff with SVA to talk about some of the tax issues.
Thank you. One of the things that we're seeing is obviously that lots of people are concerned with how to pay for all this. And then additionally, there's been a lot of movement in the last few days about when payments of income tax are due, when tax returns are going to be due. I'm going to address the credits that are designed to pay for this paid leave, and Eric will be addressing due date issues. So it's important to understand that Congress really was trying to make sure that all of your out-of-pocket cash for paid leave is something that you'll be able to get back and that you'll get back quickly. So they've established these two credits, and you'll see that there's the payroll credit for required paid sick leave, and then there's payroll credit for required family medical leave. These are, as you can see, they have dollar amounts and caps that are tied back to the amount of leave that an employee is actually allowed to receive. And that's very specific. That was done for the reason that we are trying to make this as cash flow neutral as possible. We can move on. So in addition to the amount of paid leave, in a lot of cases, you're going to be able to get a recoupment of the health insurance that you pay out to employees who are on this leave. You also need to understand that these paid leaves are not considered to be taxable wages for purposes of Social Security and income tax withholding. So you're not going to have an additional tax expense, nor will the employee, for receiving this paid leave. That's all very important because that comes back to how are we going to pay for this? How do we make this cash flow neutral? And if we move on, there are some important things that you need to understand. A lot of people, when they heard that Congress is going to be reimbursing through tax credits, they got very concerned because they thought that I'll be paying this now and I won't be able to get reimbursed until the end of the year when I file my income tax return. Well, fortunately, that's not true at all. These tax credits are payroll tax credits, which means that you claim them every quarter. You'll claim them on your 941 when you're reporting your taxable wages and payroll tax deposits for the quarter. Additionally, they have made this refundable. So if you have actually paid out in paid leave more than you had payroll deposits that would be able to offset it, then you'll be able to get a refund. So what does all this mean? We move on then. So we're trying to get down into the nitty-gritty of how do you actually get the money. Unfortunately, Treasury Department's released what they're calling Release 2020-57. The law gave the Treasury Secretary a lot of latitude to be able to let employers, we might call short pay, their payroll deposits. Specifically, that means that the law contemplated that you would estimate as you went how much credit you were going to be eligible for, and then you would subtract from that you subtract that amount from the deposits that you're taking. And so Treasury's come out and specifically said, yes, you're going to be able to do that. You can retain funds from income tax withholding and from the employee and the employer share of Social Security and Medicare taxes. Now, hopefully, you only have a small portion of your employees at any time that are subject to the paid leave requirements, and therefore, hopefully, the amount of credit that you claim and that you're able to withhold from your payroll deposits is going to cover that. However, if it doesn't, the IRS is also preparing an accelerated refund process so that employers, if they cannot recoup all of their costs by reducing their payroll tax deposits, they can file for a refund. The guidance on that is supposed to be available next week. The IRS says that they expect to be able to process and pay all claims within 2 weeks. Now, I think we all know that the IRS sometimes is not able to meet those types of goals, but that's what they're saying they're going to be able to do. So let's move on now and get a better understanding of how this would work. So say you have an employer who pays $5,000 in sick leave as required by the Act. And for that same payroll period, he's required to deposit $8,000 in payroll taxes and employee withholding. So instead, he would only remit $3,000 with the payroll tax deposit. Then when the end of the quarter came, he would report all of his wages, all the withholding, subtract out the credit, and reconcile that to what was actually paid. Hopefully, those will all tie out. I think the government's understanding that, at least to begin with, this being something brand new, there may be some errors. So if there are mistakes, I am hopeful that the IRS will be fairly lenient as far as assessing any penalties or interest. So another thing that we want to address is what if you are the employer and you're somehow affected by COVID-19? Well, that's going to depend to some extent on how your business is orchestrated. You are also going to be allowed to claim a credit. But that credit, if you are organized as an S corporation or a C corporation, that credit's going to work just like any other. On the other hand, if your business is organized as a sole proprietorship or partnership, you'll not be able to claim the credit until the end of the year on your income tax return. but you would be able to reduce your quarterly estimate payments. Now, I also want to go on to another example. Let's go back to that prior example. We've got the same facts, except now the employer has an $8,000 payroll tax deposit requirement, but they paid out $10,000 in sick leave during the period. So that's when you would withhold the entire amount. You wouldn't remit anything to the Treasury for your payroll tax deposit. And then additionally, you would go to this IRS process and file for a refund of $2,000. To wrap this up, as far as how the payroll tax credits are going to work, we want to try to address some questions that have come up and some misconceptions. Again, you don't have to wait till the end of the year. The idea is to get this money to you as quickly as possible to fully reimburse you. That is the plan. If, excuse me, and if there's, for some reason, the amount of taxes that you are required to pay isn't sufficient, the IRS will still get you the money. Now, there have been a few questions that I want to hit. One of them that's come up, it says, well, if an employer isn't covered by these paid leave acts and they still offer paid leave, can you claim the credit? And there's a lot of reasons why that might happen. If you're over 500 employees, but you decide to pay the credit. If you decide to start paying leave before the effective date, April 2nd, or if you were expecting to fall under one of these 50 or less employee exemptions that doesn't materialize. So if you pay leave that you weren't required to under the law, unfortunately, it doesn't seem to matter what the reason is, you're not going to be eligible to claim the credit. So you may be doing it because it's the right thing to do for your employees, but in that case, if you were not mandated under one of the leave acts to pay paid leave, you cannot claim the adjacent credit. Another thing that we need to talk about is how do you confirm that the employee is going to qualify? And as as was mentioned earlier, there's not any specific guidance about this. But my recommendation, as someone who knows the IRS and is paranoid, is that you at least keep some sort of reasonable record of what you did to verify that they were eligible. Again, hopefully the IRS is going to come out with some guidance. All right, and with that, I'm going to turn it over to Eric.
Thank you, Jeff. I'm going to talk a little bit about the income tax deadlines. So I'm going to draw a line right here. Up till now, everything you've been hearing is related to the Families First Coronavirus Response Act. So that was a law going through Congress and signed by the president last week. And it encompasses everything that you've heard of up to date. What I'm going to talk about now is not in that law. This is something different that just happened to be occurring at the same time. And this started with the way that a lot of rules start with this administration. It started with a tweet. So President Trump got out and tweeted something to the effect of, hey, nobody's going to have to pay their taxes by April 15th except the very rich. And so that tweet was put out there, and the IRS now is an administrative body, and they pick that up and decide, well, okay, how do we incorporate this into our rules? And they issued some guidance, and within that guidance, the IRS said, okay, we'll postpone your tax due date, or at least tax payment date, until July 15th. And they said, okay, who should have to pay and who shouldn't? Well, if you owe over $1 million as an individual, you have to pay. And if you owe over $10 million as a corporation, you should have to pay and not get this extension. Those numbers, you'll notice, aren't in the slides. And the reason they aren't in the slides is because that is now an old rule. And a new rule came about again just last week saying that that's not true anymore. So a point of importance here, if you're reading something about how these deadlines have been delayed till July 15th, and you come across something that says 1 million for an individual and 10 million for a corporation, put down what you're reading, because it is now old and it's been superseded by what I'm about to go through right now. So the new rules now, the deadline of April 15th for individuals and for C corporations that have a calendar year end, which is also April 15th, that deadline's been moved to July 15th. And so what does that mean? Well, not just the deadline for paying, but also for filing your tax return. So April 15th this year means almost nothing. We'll get to what it maybe it could mean something, but right now it means almost nothing. And the reason is, if you're an individual and you normally got your stuff done and all your accountants were working around the clock in those first 2 weeks of April to get information in and get your tax return filed, that date doesn't mean anything anymore, because it's now July 15th. And if you owed money, normally you could file for an extension and say, okay, I can't get my work done by April 15th, but I've got to pay the tax and I can file for an extension. That April 15th doesn't mean anything. You don't have to pay the tax on April 15th. You have until July 15th when you file your tax return to pay the tax. You can still ask for an extension at that time, but you don't have to do anything right now for the April 15th deadline. You can erase that right out of your current calendar this year, okay? We might have to put it back in next year, probably, but right for this year, you can erase that out of your calendar. Now, that's all well and good, but the IRS and the government doesn't make that rule for the states. The states get to make their own rules for due dates, and each state is responding in turn to this. Wisconsin responded this weekend. Wisconsin did adopt the same federal dates and the same federal payment due dates, so July 15th. So for Wisconsin, if you have a tax return due, that would be April 15th, like your individual return. That due date now is July 15th. If you owed money on your individual return for 2019, you were going to have to pay it in by April 15th. That date is now July 15th. Let's move on to the next slide. Because this 15th date also happens to be the date when first quarter estimates were due. So estimates typically paid by self-employed individuals or individuals with businesses that say offer flow through income. Those individuals are paying their estimates on a quarterly basis. It's not all through withholding on their paychecks. Just like corporations are paying their estimates on a quarterly basis. That first quarter estimate, if it was due April 15th, like it is for all individuals, that first quarter estimate is now due July 15th. And that's the same for Wisconsin. So quarterly estimates normally due April 15th, and then your second quarter is due June 15th, and third in September, and fourth at the end of the year. That first quarter estimate is due July 15th. The second quarter estimate, though, as of right now, is due June 15th. So until that rule changes, and we do expect that rule to change, just don't know when. But until that rule changes, second quarter estimates are due June 15th. So you have somewhat of an absurdity right now where your second quarter estimate is due prior to your first quarter estimate. Your second quarter estimate's due June 15th, your first quarter estimate's due July 15th. That's what we expect the government to change. So that's true for both federal and Wisconsin. Those estimates have been moved forward to July 15th. We could go to the next slide. So what are other states doing? There's a couple organizations that are gathering information and trying to put it out there. The AICPA is one, to round up what all the state estimate and due dates are. Most states are following suit right now, but some states are offering variations to that, like they might say July 31st instead of July 15th. So on a state-by-state basis, you will have to look at, what your current filing needs are and what the new due date is. But I would expect most, if not really all the states, are going to adopt some kind of delay for this. Next slide. So a couple questions that have come up on this. Main one is, what about my IRA and HSA contribution? So normally my IRA contribution and HSA contributions for the 2019 year are due on April 15th, just like my tax returns do. With this postponement, does that mean my IRA and HSA is due on July 15th instead of April 15th? And right now, we don't have a clear answer from the IRS, but we do have a number of organizations that have made an interpretation, including an article in the Wall Street Journal and some of the wealth management websites I've been perusing. They're all saying that it looks like July 15th is that day that an IRA or HSA is due. But again, that's not from the IRS. That's from conclusions that are being drawn right now with the way the law reads. So expect that to be July 15th. I actually expect the IRS will come out with some guidance within a week or so that addresses IRAs and HSAs and says that indeed July 15th is the new due date for those. Second question that came up is what happens if I extend my return? So on April 15th, you used to be able to extend your return all the way to October. It was a 6-month extension. So now that the return's due July 15th, does your extension go through October 15th like it did in the past? Or is it still a 6-month extension? And does it go all the way then to January 15th of 2021? As of yet, that's not clear what the answer is going to be. Again, we expect this to come out with IRS guidance in the next couple of weeks or so, indicated that this is a question they've been getting. And a final question is, well, is the IRS still working right now and issuing refunds? Because let's say as an individual, you have a refund coming. Well, you don't want to wait till April 15th and certainly don't want to wait till July 15th to apply for that then. So you want to get your tax return done now and still try to get your refund. The IRS said they are still processing tax returns and refunds should be as timely as they have been in the past. So they expect a refund in 2 to 3 weeks if you do file electronically. So that's what I wanted to go over. There's a couple minutes left here. Turn it back over to our moderators, or if they want to get it to Godfrey Kahn, if they wanted to answer some of the questions.
This is Meg Kurlinski from Godfrey and Kahn, and we've seen some good notes come through on the side that we will try to address. We've had a couple people question whether those numbers that we gave for caps and aggregates are per employees or for the total workforce, and it is per employee under the regs. We have also had a number of questions about how the Safer at Home order plays into the PSLA. And Rebecca touched on this briefly. It's going to come down to each order, and in Wisconsin we have the Safer at Home order, and whether or not it is going to trigger the quarantine or isolation that is referenced in that first prong of the leave. So if an employee is subject to a quarantine or isolation order, they would be eligible for that 2-week entitlement. We are still working to verify how we feel on the Safer at Home and how it interacts with that, but that's what we're going to keep an eye out for. So stay tuned for guidance on that. We have also received some questions about whether an essential business kind of impacts whether or not employees are eligible for either of these leaves. And it doesn't take away your coverage as an employer if you're an essential business or if you're not an essential business. These leave entitlements still attach to your companies, but it will play in, as we just referenced, to if these Safer at Home orders are going to require your employees to be at home and whether the leave covers. We've had a question on layoffs. If an employee is on layoff because you have had to downsize for whatever reason, are they still eligible for these leaves? And our position is that they are not, because they are leaves from work, otherwise not able to work due to these reasons. But if someone is on layoff, they are unable to work due to other business reasons generally, but definitely consult with counsel when you are implementing these layoffs, because there are a lot of leaves at play. Rebecca, do you want to hit on the collective bargain employees really quickly?
Yes, absolutely. So union employers with unions or who are subject to labor agreements are covered by the Act and required to comply. The Act specifically says that an employer that's a signatory to a multi-employer collective bargaining agreement may, consistent with its bargaining obligations and labor agreement, fulfill its obligations by making contributions to a multi-employer fund, plan, or program based on hours of paid sick time each employee is entitled to while working under the labor agreement, provided that the fund, plan, or program enables employees to secure pay on hours worked and use as specified. If you don't have a plan, this may be something that might be a subject of mandatory bargaining. So it is something that if you're an employer with a union, you're going to have to comply, and you're going to want to reach out to counsel for some guidance on how best to do that. And lastly, we received a question about whether or not policy should be issued. While you're not obligated to provide a policy, only to post the notice, we think policies can be really helpful for setting expectations, because there's a lot of information out there that might be misleading to employees about what they can use the leave for. And so we think that creating a policy, it could be helpful. We have way more details available on our blog, as well as on a take-home piece that we'll be sure to share. That's it for me.
Okay, thank you to our presenters today, Rebecca, Meg, Eric, and Jeffrey. SVA has also created a resource page where the recording of this webinar will be located, as well as additional information on the coronavirus. Bookmark svaccountants.com/COVID-19 as a resource for you and your business. We also wanted to let you know the SVA team is only a phone call or email away, so reach out to your SVA professional as questions arise. If you're not currently an SVA client, contact Lee Schwartz, who will be happy to help connect you to an SVA professional that best fits your needs. Our next webinar is scheduled for March 31st at 1 p.m., and we will cover recent legislative and lending updates. Here's a sample of what we're going to cover, but we are keeping the content open until we see exactly what is going to be passed this week in the legislation. Registration will be available later this week, and you will receive information on that as well. Thank you very much for joining us today, and we hope you all have a great day.